Okay, well there we have a wonderful, Chad, how you doing? Can you confirm how many people in Ottawa, Ontario are on ODSP once more? I will, that's our next slide. Thank you very much, Chad, I appreciate that. You'll see here on this slide that there are 378,802 people on ODSP. So that's a fairly current number. We're on a first name basis with the ODSP statisticians because we find all of these things fascinating. You'll see also that the population of Ontario is about, last count, was about 13.7 million people. And what StatsCan says is that if you take the number of people and you divide by 3, this will give you the approximate number of households, which when you stop and think about it intuitively is probably pretty realistic, 3 people per household roughly. Some will be 1, some will be 2, some will be 6, but on average, let's just say 3 people in a household. So what that gives us is 4,566,000 households. And what we know is that 378,000 of those households have a child with special needs or disabilities, so a family member with special needs. And this, of course, doesn't include all the kids under 18. They're just not included here. You'll see when I show you the breakdown by city that a certain number of people under 18 will be included, but it's not representative. And if you look at the people that are over 65 that until last week were on ODSP, but now they're 65 and they're on OAS GIS, that's approximately 1/3 more of that number. So you can easily see that you could round up the 378,000 to 478,000 pretty easily. And then if you compare that to the 4,566 households, you can see very simply and conservatively, and only dealing with people who are on ODSP, not LTD, not CPP disability, not workers' comp, none of those things, just ODSP, that is 1 family in 10 that is a household that is directly concerned about this person, which is a phenomenal number. I mean, what other single community can you think of that is 10% of the population? Yes, there are some, certainly, but it's a very large number. Is that a good answer, Chad? Now, this is the breakdown of the types of disabilities. The one thing that I haven't figured out yet, and I'll have to ask the statisticians, is where would autism spectrum fit into this? Because it's not necessarily a developmental disability, is it? There could be a cognitive disability, that's true, but where would that fit? And I don't know the answer to that, but this is the rough breakdown. So you can see that when we get to the question of the disability tax credit, you can presume, I think it's a fair presumption, that this number here, which is, so there's all the numbers underneath, you can see. This is a developmental disability, which probably that person would qualify for the disability tax credit. That's 19%. A good number of the psychoses and neuroses would qualify as well. Physical disabilities, Parkinson's disease, 9%. Circulatory, musculoskeletal, physical illnesses, a lot of those would qualify for the disability tax credit as well. So you can see that when we get to discussing the disability credit and registered disability savings plans, that this is again a large number, and this is just in Ontario. Let's see what kind of questions we've got. I'm sure that all of you are looking at questions and considering which ones you want to answer. When I was speaking with Karen earlier, when it comes to the questions about getting benefit increases, she's happy to talk to you, but you might find it simplest if you just email her afterwards as to how the benefit increases are worked out. We will speak about it, of course. And Chad, you can see here that these are the numbers in the different municipal areas. And where's Ottawa? There's Ottawa. So you can see that Ottawa, which has a population of approximately 1 million, and that's what it says at least on the sign coming in on the East End, has 25,496 people on ODSP. They have households one way or the other with children or spouses of 34,805. And you can see this number here, this ACSD number. Well, those are children under 18 in low-income households, children who have disabilities who are in low-income households. So you can see that it's only 2,024, but that's primarily not so much because it's not a severe disability. That's not the issue. It's that they're in a household that has income of greater than $45,000, for example. Are there any questions about those numbers? They're all fairly self-explanatory, I think.
I don't see any.
Okay. I see there's questions coming in about disability tax. Hi, Janice. We'll get to the disability tax credit in a moment. This is the slide that deals with benefit increases and tax credit recaptures. This is just the short bullet about benefit increases. There are two amounts. And everyone who's on ODSP from when they're 18, for example, well, obviously, and at home, they'll be slotted into the room and board 896 amount because, of course, their parents do provide them with a room plus food. But we're able to break out a lot of these by setting up an arrangement to break it out to shelter plus supplementary benefits, which is 1169. And what this involves is preparing a lease between the parent and child, and also trying to establish or assist the child who is just 18, regardless of whatever their disabilities might be, to shop and cook. So what you do is you break the situation out of the 896 with a rental arrangement and shopping and cooking. Karen will speak more to that, perhaps some of it today, but otherwise, if you have a child at home, 18 and older, and they're getting 896, which they are, then she'd be happy to speak with you, and you'll get her contact details later. By the way, the first question, of course, is, well, we have several questions. One of my clients was kind enough to give me a 4 or 5 point breakdown on what were their first concerns about this issue. Well, will I lose what I have if I try? And do I have to declare it as income and all these things? And no, it's not income because you're not in pursuit of profit. And no, you won't lose the 896 and so on. With respect to the disability and caregiver credits, we find regularly, all the time, that there's a very common profile of families where either the child clearly would or should qualify for the disability tax credit, but either the parents just didn't know about it or didn't apply, or were convinced by someone that it wouldn't apply to their child. You know, some doctor saying, "Oh well, no, he'll never qualify. I can't see my way to sign the T2201," you know, or you know, some other dissuasion. So we get people regularly approved for the disability tax credit. And what this does is it allows us to do up to a 10-year recapture of taxes paid and to capture them back to be returned to the party who could not at that time make use of this credit transferred from the child. And they're approximately $1,600 a year. So going back 10 years is approximately $16,000. If you happen to have taxes owing, you may not get all of that back if you have taxes owing, but your taxes will be paid. So that's always convenient too. And then the caregiver credit is a credit that doesn't kick in until the child is 18. And up until 2017, the child had to live with you. So you can see in an optimal situation, it would be where the child has resided with you and is 28 or older, So that the recapture is a total of the maximum of 10 years. And the recapture as of today is about $9,000. It'll increase slightly until 2022, and then it'll be a consistent $1,000 a year. And we'll get into these factors some more as we proceed. Oh, there's Irving. Hi. Please distinguish between the disability and CPP. Well, the disability tax credit is an approval based upon the approval of a T2201 form by Canada Revenue, and CPP is just Canada Pension Plan. I presume you mean Canada Pension Plan disability benefits. And that's just a federal benefit like ODSP, which is provincial, that is paid if within 4 of the last 6 years you contributed to Canada Pension Plan, and then you could no longer work. It's a higher test than ODSP, and which we'll get to in a moment, where the test is, can you function in a competitive workplace? Not, can you not work at all, basically. Need to understand the Henson Trust. We'll get that, of course. Do doctors have any training at all or continuing ed about how to complete the DTC application? Not to my knowledge. Some of them, of course, have done it before, but I'm not aware that, aside from, for example, if you're a dialysis doctor, a kidney doctor, then you might well know that dialysis qualifies the person receiving life-saving therapy for the disability credit. You might specifically know about that, but I wouldn't say it's something that's on their agenda. Just to give you some numbers about the at home, you can see here that of all family structures, you see borders, all family structures at the bottom, 48,233. What this means is that of the 378,000 people on ODSP, 48,000 are at home with family, which is approximately 13%. So what you can quite likely extrapolate from this is that that they've been slotted into the room and board amount, and if they're broken out of it, those families will each get $273 more a month. Otherwise, if you do nothing, then it will never change. I see we have 437 people registered. That's probably the full number that we'll get for this evening. It's just a little over half, almost exactly half of the 862 that registered at the start of the, when we first started sending out the invitations a few weeks back. I'd like to reiterate as well that if you're online, you can ask questions on the bottom, either anonymously or not. And if you click on the top of one of the speakers boxes, you can reposition that video so that it doesn't obstruct the view of other things. Here are the basic questions about ODSP, how to qualify, and the criteria is less than the requirements for the disability tax credit. Disability tax credit is that you have to be markedly restricted or take substantially longer, or be unable to set and keep goals, or to be physically disabled in some way, or restricted in eating or feeding or elimination, those sorts of things. Whereas for ODSP, it's that you either can't function in a competitive workplace, or you can't function in the community, or you can't handle personal care. Here's the monthly benefits. This is just another bullet about the increase of what is provided with ODSP, and the fact that the rule now, as of September 1st, 2017, is that it's no longer an asset test of 5,000, it's 40,000, which gives us a little more elbow room, and an additional 10,000 if it's a couple. And the amount of money that a person on ODSP can receive from any source over a 12-month period is now 10,000. Used to be 6,000. Used to be that you could receive 6, but you could only have 5, which people found a bit confusing. Does anyone want to make any of the other speakers want to make any?
Yeah, there's a couple questions here about asset limits that maybe Crystal can answer. The first one is, are the ODSP asset limits based on cost of stocks and bonds, or would it be based on market value?
Well, especially now in this pandemic that we're in, a lot of the markets have gone down, and it's definitely based on what the current value is. That's how they would count your assets, not what you purchased them for in the past, because there's a lot of investments that are taking a hit right now. So in actual fact, it would leave you more room in your asset test, but then you'd also have to keep an eye on them for when the market kind of comes back to make sure that you're not surpassing the asset test. And another thing I wanted to say, which Ken just touched on, was the voluntary payments of $10,000. It is also, if you have a spouse or like children in your benefit unit, it's $10,000 per member of the benefit unit, which is kind of important when you're adding income to a household.
Yeah, definitely.
Crystal, would you mind saying a few words about employment income on ODSP and perhaps the caregiver relief benefit for people that are on ODSP?
Well, up until now, the CERB benefit was treated, like the initial pandemic relief benefit was treated as income. And the way ODSP treats it as income is the first 200 is exempt. And then they take 50% off your check of every dollar after the first 200. So the 2,000 that people were getting brings it down to 1,800, cut that in half. So 900 would be taken away from your check. Some people have like housing and they don't qualify for the 900. So what ODSP has recently done was they included like a COVID benefit legislation into their act. And they're saying that even if you basically work your way out of ODSP because of this pandemic relief benefit, that they're still going to cut you a check for $2.50 so that you don't lose your health benefits, which I think is great. But then they go and they introduce these new 3 benefits, and the 3 benefits are now being counted the same way EI is being counted or CPP is counted. And they're deducting that dollar for dollar. There's no exemption. There's no 50%. If you're taking the benefits after the 2000, the initial, I think it was 7 months that they did it. If you're taking these new benefits, they are being deducted dollar for dollar. So that's pretty important for people to know, I think.
This is for people on ODSP and getting that benefit.
Yeah.
Crystal, there's a question here about, can you explain voluntary payments over 12 months? Could you speak a little bit about 10,000 over 12 months too?
So the 10,000 over 12 months, the law reads from any source for any reason. So you can accept gifts or payments from your investments, or if you have like a Henson trust or an inheritance account and you're adding money to your normal everyday bank account, you can accept 10,000 per 12-month period, basically without very many questions. I mean, it's ODSP, they're going to ask questions, but they're not going to dig into your life very hard if you stay within the 10,000 rule. A good thing to know is that payments from RDSPs are not counted in that 10,000. So you can get some extra money if you have an RDSP that is ready to be paid out.
I see that there's questions coming in that that relate to certain issues like disability tax credit transfers and various things. We will try to answer these in the background as much as possible, but it's obvious we won't get to all of them. I mean, there's 438 people here. If they all ask one question, we're just not going to get to it. So what I suggest is that if your question doesn't get answered or sufficiently answered to the best of our ability this evening, that you contact Karen, as you'll see on the last slide, and she'll direct it to the right person here, and they'll do their best to give you some simple answer. So this one is the recovery caregiver benefit. This is as of September 27th, and what it says basically is that you can get, if you must remain at home or can't work up to 50% or more of your regular work week because you're caring for someone, for a dependent, due to COVID, then you can receive this caregiver benefit.
This is the one that I was talking about, Ken, that's being deducted 100%. So if you take the 500 per week, expect a 500 reduction in your ODSP benefits.
For all of those people that aren't on ODSP, it applies both if you have to be at home with your child who's in school under 12, because schools do get lockdowns, they do get quarantines, and you have to stay at home with your child. Or if you have a child over 12 as well, who has special needs or disabilities, and you have to stay at home to take care of them, either because their programs are closed, or you can't get caregivers to come into the home, then you could also qualify for this. This is a slide about getting approved for the disability tax credit. I'll just let you read this, and then we'll get on to the follow-on questions. If you need to check to see if you are using it, then the most common scenario would be that you are or are not using it for your child. In that event, you'd be looking at line 318. It's actually 31800, but that's the caregiver disability credit transferred from a child. If you, and we try to keep our eyes up, if you happen to be an older parent, you may well know and use the disability credit for your son. But what about you? You spend your time being a caregiver for your child, and you're retired, and now you're 88 or 92. Well, would you qualify for the disability credit? Or have you just been too busy to think about that? So if you are market restricted, if your walking takes substantially longer, that kind of thing, then you could qualify as well, and you would use it on line 316. And if your spouse qualified, because she or he doesn't pay taxes, but you do, that would be shown on line 326 for the spouse transfer. Now, the most common profile that we find is that either the credit wasn't used ever for various reasons, or it hasn't been used for many years, often because the child has gone into supported living and someone told that person, the parent, that the child had to reside with them, which is simply not true. The transferability factor is, do you help them with necessities in the way of food, shelter, or clothing? And you don't have to, obviously, if the child's in a fully supported caregiving situation, you're not paying rent, but you might well have them home on alternate weekends or Christmases, different times, in which event you would provide them with shelter, food, clothing. No doubt you'll buy them clothing. And so these credits are still transferable. This is a very common question. And we'll get to more about the caregiver credit in a moment. But the caregiver credit is for you as a caregiver after the child turns 18. So we'll get to that further. Do we see any more interesting questions we should answer? Let's just see. Well, there's Arnold. Thank you, Arnold. That's very kind words. I appreciate that. So the next slide is, again, a new thing, and that is anyone who is already approved for the disability tax credit has already likely received a single $600 payment or bonus benefit. You can see the timing that's expected here. And of course, we're in the process, we do a lot of tax work, and we're in the process of hustling, because once we get past the end of December, we can't claim back to 2010 anymore. Once we're into 2021, we can only claim back to 2011. So we're trying to get everything filed that we can before the end of the year. And even even if we've put in the disability tax credit application, we've had the T2201 completed, perhaps, or maybe it hasn't been completed yet, we would put in the adjustment for the year in paper, just so that it's filed. And then once we get the disability tax credit retroactively approved, then the credit adjustment is applied. So this is the same every year for us. That, around about this date, we have to make sure we're hustling to get everything we can filed, because otherwise we lose a year. Anybody want to make any comments about anything so far? The caregiver tax credit. It's relatively easy to apply this if you're already using the disability tax credit, but it doesn't turn on the disability credit. It turns on you being a caregiver. And so there's no approval process for that by Canada Revenue. It's just a matter of, does it apply? Is it true? And normally it does apply. And we can discuss those, the details of that. Again, that would be Crystal that would deal with that part.
Yeah, I just wanted to say one thing. I've noticed through filing the caregiver that even if you applied for the disability tax credit and you were denied, for example, because it's a hard test to pass the disability tax credit, but if you were denied, then it shows that you have medical information on file at CRA. Whether they accepted you for the disability tax credit or not, you still have that information is on file. And you don't have to, they will not question you at all if you file the caregiver tax credit. Whereas if it's just kind of like a new thing that you just kind of add on and you've never applied for the disability tax credit, then usually they would want like a letter just confirming that there is some kind of disability. And that's the reason why you're claiming it.
Yeah, you still have to support your claim.
Yeah. But I find that even if you're apply and were denied, that's kind of like supporting your claim right there.
That's true. Eh? So we do a lot of this work as well. I'm going to just hark back to one of the earlier slides. You can see here that until 2017, you could only use the caregiver credit if the child resided with you. So all of the 43,000 families that had the child living with them, they could use it. But what about all the others, the 367,000? 78,000. Well, if you got 48,000 living at home, up until 2017, only those families could use the caregiver, but they changed the rules in 2017. They removed the reside with requirement. So now I think it's a pretty safe bet that almost all of the 378,000 families with people over 18, not counting seniors over 65, but you can see that now the $1,000 per year tax reduction, which previously until 2017 only applied to 48,000 households, now arguably applies to 378,000. That's about 330,000 more. 330,000 times 1,000 is a big number. So that's the biggest thing that's changed there. We're doing pretty well. We're 35 minutes into this presentation. Approval for the disability credit means that an RDSP can be opened. I expect we're going to have a number of questions about RDSPs. And in a simple world, once the child turns 18, the grants and bonds are based upon the child's income, not the family's household income. Prior to age 18, it's based upon the parent's household income. And if that household income is greater than $34,000, then the child wouldn't get the $1,000 bond each year. So typically they don't. But if that family household income is less than $95,000, then if they contribute $1,500, the child would get the $3,500 grant. Above that dollar number, above the $95,000, the best that happens is if you put in 1,000, the government gives you 1,000, which is better than a kick in the pants. But what I find is that usually I suggest to people that that they just wait until the child's 18, they're on ODSP, and then they get the maximum grant and bond, and they get all of them. It's just that they don't actually get the government money until slightly later. And yes, that's a factor. If it had been properly invested, there might have been some growth. And, you know, in a perfect world, if your household income is less than $95,000 and your child is 2 and they've been diagnosed with autism, for example, and are approved for the disability credit. But I find typically that parents don't get around to all this stuff until the child is 7 to 9, at which point they're in school or in care and they've had their diagnoses and there's different treatments that have been tried. And finally, the parents have a little bit of breathing space. So I just recommend that you wait till the child's 18 and collect it all afterwards in the next 20 years. And we'll get to a slide in a moment that explains how this can accumulate to a very substantial sum. Are there any questions about RDSPs?
Yeah, there's one, someone's asking, Paul's asking, are RDSPs sufficient to protect money and avoid clawback of benefits? Crystal?
Protect money and avoid clawbacks. Well, yeah, sorry, I'm just rereading the question. RDSPs can hold personal contributions of up to $200,000. And when you put that money inside of an RDSP, it no longer becomes a countable asset for ODSP purposes. And then when the money is paid out, after, there's tons of rules, but just to keep it simple. So after the government puts in their last grant and bond, which they do that for 20 years, after 10 years, they start to pay out money. And that money that they're paying out is not also not counted in your 10,000 rule, the 10,000 per 12-month period rule. And it's not counted as income at all or an asset in the following month. So as long as the money comes from an RDSP, it can go in and be exempted and it can come out and be not counted. So it's actually a very wonderful tool. And there's lots of rules that need to be applied that people should know about before they just go ahead and do this. And if you want more information, then I would say give us a call and we'll have like a private consultation.
There's another one here from Lena that maybe you can answer too. When should a parent with an adult dependent child stop contributing to their RDSP because of the 10-year rule?
Well, I would say that you should try and get as many grants and bonds as possible. I mean, there's always exceptions to situations. For example, we have a client family whose child, his life expectancy is going to be shortened. And because of that, you can get a letter from a doctor to basically void the 10-year period, and you can get certain amounts of money without penalty and keep your grants and bonds. But the government will put grants and bonds for a normal person. The government will put grants and bonds for 20 years. So I would say get as many as you can. And I mean, it would make no sense to not take $4,500 per year from the government that they're going to put into the RDSP. If the parents put $30,000, the government puts $90,000. I'd say get your whole $90,000.
Good advice. So you can see the simple numbers here. The next slide that we look at will show you how contributions, in a simple example, starting at age 18 and progressing up to age 60, invested at 5%, how it all works itself out. But the short story here is you can see that if you make those contributions and they're invested at 5%, which is realistic really, even in today's world, that when the child's 60, they're approximately 700,000. And then using the standard LDAP formula, they would pay about 30,000 a year for 23 years. That's a pretty fair deal. There is an online savings calculator, aggregator calculator, and this is what it would look like if your child was born in 2000, they became eligible for the DTC at age 6. You started the $1,500 contribution at their first year, seeking age 18 here, you see, and invested it in overall at 5%. And it says here, this is slightly misleading. The adult gross family income, really what that number would be is gross. That is correct. Adult gross income. That's the child who's on ODSP and getting 1169. So what you can see here is that by the time the child is 60, because they're born in 2000, it adds up to about 700,000. And here's the calculator. Here's the URL for that calculator if you want to play with it sometime. I'll just let you look at this for a moment. And I'm looking at the questions as well. So I'll go to the next slide. And you can scan these or review them at your leisure once you get these after the presentation. This is the vocabulary that comes into play closer to the time that the child is actually going to start to receive money. And I'd just like to clarify something. If you're in your 20th year of contributing $1,500 and you want to try to take money out because, of course, after 10 years, the first contribution is vested. And after the 9th year, after 10 years after the 9th year, first to 9th year are vested, the grants and bonds. But if you then decide in the 20th year to try to take out the money, well, there's a full 10-year vesting period after the 20 years. And the contributions that you've made in those the second block of 10 years, if you try to take money out, it's deemed to be withdrawing also grants and bonds. It's basically 3 to 1. So that it's first out, first out, first in, first out, last in, first out. So if you try to take out the money that you put in last, it's not being matched up with the money you put in first, because those grants and bonds are vested. It's being matched up with the grants and bonds for the year in which you put that money in. So the child can't really benefit except in certain circumstances until 30 years have passed, not fully anyway. Now you will find situations where you do have to, for health reasons perhaps, you have to close out and forego the grants and bonds for the non-vested periods just to hold on to the remainder. But that's a calculation. It's not a common calculation, but it is a factor, of course. So now we're getting into the fact that the child does have assets now that they have an RDSP. And if they're not competent, then the parents could be the account holders for the RDSP. They're just the account holders. It's not their property. They are not the beneficiary of the RDSP. It's the child's money. So here we get into the differences between guardianship, powers of attorney, substitute decision makers, and trustees. And I'm hoping that Rafiga and Diane will be able to speak to these points. Diane, would you start with powers of attorney and then sort of move on to guardianship, and then have Rafiga speak to guardianship as well? These lawyers both have a great deal of experience with this work. And it even slides into guardianship by daughters of mothers, and daughters for grandmothers, and husbands for wives, even though her mother and her sister doesn't like him. And it can get very interesting. But they know all the horror stories, and can explain these things. Diane, would you mind speaking about the difference between power of attorney and legal guardianship? That's always the first question I get.
Sure. The main difference is the type of power that you're giving. So with a power of attorney, that person is giving their attorney the power to make decisions when they are not capable. And so, for example, maybe they're just sick one day, or maybe they carry out a power of attorney because they want them to deal with property that is in another country and they just don't want to pay the cost of the flight to go there directly. With a guardianship, the appointment that you're giving, the power that you're giving to the guardian is a lot stronger. And it also deals with the person's capacity to make decisions. So with the power of attorney, there is no evidence that you have to put forward that this person cannot make their own decision, because that's not important in this document. But for guardianship, in order for guardianship to be granted, you need to put evidence that this person lacks the capacity to take care of their financial affairs or their own health care. And I see that we have some questions about guardianship.
Well, as long as you clearly point out that the personal property power of attorney can be canceled if the person is competent, which I'm sure you have, and that guardianship is by court order because someone has been assessed to be found not competent, and that the powers of attorney are both for property and personal care.
Yes. So the evidence that we put forth is through capacity assessments. And so that's where a capacity assessor will sit down with the allegedly incapable person and ask them questions about, their daily life and how they manage their nutrition, their clothing, their shelter, their hygiene, and then also how they take care of their own accounts.
Raffiga, would you say a few words about some of your guardianship files? You've had some very interesting ones.
Sure. So a lot of the questions that we get has to do with what happens after a guardian passes on. Can it be transferred? Well, the short answer is it cannot unless there was a co-guardian acting in his or her capacity as guardian. So normally what happens is, as parents, you would have already these relationships formed with service providers, healthcare providers, financial advisors, bank employees. And then when both parents are gone, so what do you do? Well, you need guardianship. There are a number of obstacles that you can encounter without guardianship, and dealing with a bank is one of them. So for example, we had a situation where a bank would not release funds of the incapable person to the parents, even to the parents. Well, why? Because they didn't have guardianship. When a child is a minor, you still can do things on that child's behalf. You can open a bank account for him or her, but now the child is an adult. Even sometimes they're working, but they apply for ODSP. They get ODSP benefits. They want to go to the bank and open a bank account where these benefits would be deposited, but they can't. And so bank would refuse to do this if the person is incapable, if there's no power of attorney, if they cannot sign a power of attorney. So they often require legal guardianship. I assume my colleague Diane will elaborate on other examples later. But this was one of the examples where things can get complicated and why guardianship would be required. But now going back to the question that I was asked before, what do you do when both parents are gone? And who will continue to act on behalf of your adult child? I have a client, parents now, both parents. So they seek guardianship for their adult son. They don't have anyone in Canada except a relative in Nova Scotia and a daughter in a foreign country, not in Canada. We are in the process of adding a daughter as a co-guardian, and possibly we'll add that relative in Nova Scotia as a guardian. So these are one of the examples where, you know, parents are concerned, well, what will happen after I'm gone? And it's always advisable in our practice, when it's feasible, we do recommend to add co-applicants. Normally we would suggest siblings. So basically, yes, it's a court appointed process that you have to go through. And if you didn't have a co-guardian with you appointed, then after you pass on, then that other person who you would want to be a guardian of your incapable child, that person will have to go through the whole court process again to be appointed. So why not do it in one application and be appointed at the same time? So basically, that's one of the examples I can give. We often are being asked this question: can I appoint a guardian in my will, so that this guardian can act for my child in the future if I'm no longer here? Well, the short answer is, you can include a provision in a will that would express your wish, but it's not legally binding. So anyone who would want to be a legal guardian will have to go through a court process to be appointed. So this is, just to give you an example, this would resemble something like, you know, a mother who wants to appoint her sister to give custody over her daughter, and wants to do this in a will, but she doesn't want her husband to have custody over her daughter. Well, you cannot do that. It has to go through the court. So that would be my answer, I guess.
That's great, thanks.
I just wanted to.
Yeah, please.
I just wanted to jump in. Thanks, Rafika, for telling that story. I have clients, a lot of clients with that story about, who have that story about going to the bank and not being able to carry out any financial matters because the bank person looks at their child and says, you know, I don't think this person can sign. We're not going to let you have access to anything, or we're not going to open any account until we can satisfy ourselves that this person has someone who can legally make decisions for them. And just on that mindset, because of the way our office is, we are a legal office, the reason why some clients come to us is because they want information about guardianship, and they're having trouble managing their adult child's affairs without this guardianship appointment. Basically, the guardianship appointment gives our clients more clout, whether they're dealing with group homes, whether they're dealing with the bank or with a medical institution. You know, I have clients who had their child live with them until they're an adult. Then they grew older, they're put in a group home or a supportive living home, and it's a new environment, and the caretakers are just not doing the same things that as parents, you know, their kids would be used to. So there might be some, you know, some small arguments here and there, you know, she should get a snack at this time or something like that. So they come to us and they want guardianship because they just want more authority, legal authority, and more clout that, you know, whatever they say, they're saying it in the shoes of their child. So the group home has to listen to them. You know, I had another client who her husband was in a group home, and they didn't have guardianship. She didn't have guardianship over him, but his health was declining. She just so happened to be the type of person who would visit her husband every single day. And I don't know, for whatever reason, her relationship with his caretakers deteriorated. And at one point, you know, she was there and they said, if you don't leave, we're going to say you're trespassing. Now, this would not happen if she had guardianship, because she could argue that she had to be there because no one can speak for her husband except her. Also, I have clients who can't even do small things like book an appointment for their child who is nonverbal at the dentist because they're considered an adult and they're supposed to make their own decisions at that point. Also, you know, clients who have adult children who are still in school, probably they're age 21, and the school is not releasing any records, And as parents, you know, you want to be involved and you want to see what happens and you want to have access to these records. But without guardianship, you just don't have this this clout, this legal authority. And then, you know, I also do have clients who, you know, themselves, they did not request guardianship, but other institutions have. So again, group homes sometimes will ask the parents to apply for guardianship so that the group home can take the necessary steps and apply for other funding, government funding, for this adult child, because this person is unable to sign for themselves. Also clients who their adult child has been involved in an accident, maybe there's a settlement coming up, or there's funds that were put into court and it won't satisfy the court, or it won't satisfy the defendant's insurer about the money that they're going to be giving to this person unless guardianship is first appointed. And also, you know, as the adult child grows older, after they're out of ODSP, you know, who's going to apply for them with regards to OAS and GAS, so Old Age Security, Guaranteed Income Supplement. And then even before that, you know, if the parents have not opened an RDSP for them while they were minor, you know, who's going to apply and for the RDSP for this child, which is a long-term investment if that child, let's say they're 19 now, has never opened one by themselves. So those are just some of the stories that, you know, I've encountered.
This also brings us to another state planning factor that has relevance for the guardianship. Because if you are a teacher or a municipal employee or a hydro worker or a workman's comp WSIB worker, you will have a statutory provincial pension. And what this means is that you'll retire with a pension. If you're Omer's pension, your pension will probably be less than teachers and less than OPG. But if you're a retiring teacher or two teachers, it's not unknown for teachers to marry each other, then you could easily retire with a $60,000 pension or two of them. So if at the time of your respective demises, what happens is when the first parent passes on, the surviving parent gets 2/3 roughly of their pension, so say 40,000. And then when the second parent passes on, if you have an adult dependent survivor pension, adult dependent survivor, meaning your child that perhaps has lived with you all of their life, your son with Down syndrome or your son with autism spectrum, or you know, whatever that may be, and perhaps you've lived in your home longer because your son or your daughter was physically able but needed guidance, and you know, they would perhaps even shovel the walk and help you carry the groceries, and you know, it can be a very, very good situation in some cases. But so then you pass on. So we know that the child has a disability, and then you have to establish that they're an adult dependent child with disabilities, but they then stand to get half of your original pension, and if there happens to be two teachers, half of both. So there you look at a $60,000 total pension or a $30,000 pension if there's just one teacher, but that child can't apply for it and they can't manage it. So again, you have to have legal guardianship, and you can see how many, well, it's one family in 10 that is a teacher or a municipal employee or a hydro worker or workman's comp worker. One family in 10 of those families are going to have to seriously look at guardianship just to receive the pension, let alone the RDSP management and OAS GIS. I think I'll come back to this later, but I just want to give you a heads up that starting in 2021, the reporting requirements for trusts will increase a fair bit. You've probably seen it in the papers that all of the beneficial owners and beneficiaries and who are the trustees and tax filing returns for trusts that don't have income that these will all of a sudden become more burdensome for the 2021 tax year. So if you happen to be the trustee or are going to be the trustee of such a trust, you should be aware that the requirements will be more onerous starting in 2021. These are some of the exemptions from it. You can see that the lawyers' consolidated trust accounts, where they hold money on behalf of clients, they don't have to report who it's for, and that's a matter of solicitor-client's privilege. Graduated rate estates, that's the 3 years after a death. Qualified disability trusts, where the beneficiary qualifies for the disability tax credit, and so on. But still, there are going to be penalties for 2021 and afterwards if you don't comply with the requirements. Now, I'd say one of the most common questions that we get is, what is a Henson trust, and do I have one? Now, of course, we obviously include all of the qualities necessary in the trust that we prepare, which makes them, more unique and more powerful. And we put Henson trust in there. I very rarely see that wording listed in ones that are in fact correct Henson trust, but the client, they know they have some kind of trust in their will, but a few years later they're uncertain and doubtful and curious about what's really happening. And so what it'll come down to, Jennifer, would you mind speaking to these basic elements of what's required in the trust? Jennifer's the law clerk that works on most of the wills we have. Some of the more complicated wills, Rafiga handles as well. And Jennifer, if you would be kind enough to just speak to these items, I'd appreciate it.
Yes. Hi, hello everybody. I'm so glad that everyone has chosen to tune into our webinar tonight. So a Henson trust, in a nutshell, is a testamentary provision that is put into your will that basically will protect your child's inheritance from any ODSP clawback, or any also will protect spousal in the community property, but also it will protect from bankruptcy, I believe. And of course, Rafiga will always be able to stop in and say, and correct me if I'm a little bit off. Now, Henson Trust, it has to contain this wording, including absolute and unfettered discretion, which in essence means that any decision towards payments, any decisions towards growth, investment, anything to do with management of the Henson Trust, the trustee has the absolute and unfettered discretion, meaning that they have total discretion whether to pay out or anything to that type of anything to that type. What makes a Henson Trust also is the shall not vest wording, which means that in essence it's kind of like an oxymoron in the sense that while the beneficiary benefits from the Henson Trust, they themselves are not the beneficiary because their inheritance is not vesting upon him. It's actually being put into a trust that's managed by a trustee, and then basically the trustee disperses the payments. Now, the size of the trust, of course, is unlimited. Disbursements are unlimited as well. We have that no $10,000 limit over 12 months. We are aware of it when we do disperse payments to the trustee. But another thing that is included in a Henson Trust is one of the things is the even-handed principle. Now, an even-handed principle simply means you do not favor one class of beneficiary over another. But in a Henson Trust, there's two types of beneficiaries: the income beneficiary and the capital beneficiary. The income beneficiary being, of course, the child with the disabilities. The capital beneficiary is any residue beneficiaries after the fact. And of course, with the Henson Trust, it's all, like I said before, it's like any growth decision, payment decision, investment decision, always favor that of the child with the disabilities. Because the whole goal of a Henson Trust is for the child, is to pay for the child's life and eventually pay for the child's death as well. Rafiga, if you have anything to add, no, feel free. But I believe I've covered the basics of it.
Yep, you did.
I have a couple questions here for Jennifer, if you don't mind. One of them is, what is the process of opening a Henson Trust once the document has been drafted?
I'm more familiar with drafting the Henson Trust provision side of things. Like the basically thing, once the probate process goes through and the beneficiaries are ready to be paid, then it's time to set up the Henson Trust. And I believe Rafiga has more experience in this section than I do.
Yeah, so the process of opening a Henson Trust, well, you would normally create Henson Trust. If it would be a testamentary trust, you would do it in a will using the wording and considering other factors and adding specific wording relevant to your situation. But Jennifer did a great job in covering those main 3 elements that you would need to consider when you're drafting a Henson Trust provision in your will. But when you're opening it, assuming that it's a testamentary trust, so the person, the settlor or the testator already passed on. So now there's a different procedure you're following. You would normally contact the bank institution, the financial institution where you would want this to be set up. There are several forms that you'll need to fill out. There are several questions that you need to answer. You sometimes are required to provide a copy of the will or a notarial copy actually of the will, and a certificate of appointment as well to show that you are the executor acting on behalf of the estate. So basically those are main things that you go through when you're opening a Henson Trust. There's a lot more to that though, and we certainly invite you to schedule a phone call with us, and would be happy to answer your questions in further details.
Thanks, Rafiga. I wanted to put one more to Jennifer. What if I have nobody to appoint as executor of the trust?
Hi, thank you for that question. It's a very common question that we get, is that if we have several clients that they have no family, like they're the last of their line. They have no, like, friends have either faded away or have deceased. And so their next question is, I have only the one child, they have no siblings. Who should I appoint to be the executor of my estate and the trustee of my Henson Trust? Well, really, there's only 3 choices. A lawyer's office can offer services as executor, and they can offer services as a Henson Trust trustee as well. We also have, there's various trust companies. For example, out in Saskatchewan, there is a trust company called Concentra. They offer trustee services as well as executor services as well for clients who need an executor or a Henson Trust trustee. And finally, also we have the banks and possibly the credit unions, but definitely like the major banks, CIBC, Royal, Scotia, and TD, they definitely offer some, they offer services as executor and offer services as Henson trustees. Now, one of the things I would, of course, recommend to people is that they do their research on various banking institutions and lawyers' offices, because some of the fees can range up between 2 to 10%, depending on the institution or the banking or the lawyer's office. So I do encourage people to do their research.
That's great, Jennifer, thanks. Rafiga and Diane, did you have other questions that you called from the registered questions that you want to speak to, or shall I move on to lifetime benefit trusts?
I don't see any questions for me.
I had one question. The question was from Elizabeth: how to be sure my daughter can manage after my death? And the answer to that is, it depends on what you're asking for. Are you asking for assistance with decision making, assistance with how to take care of healthcare matters, or with financial matters? In short, we're looking at executing a power of attorney or applying for guardianship. We also have clients who want to possibly leave an inheritance for their child when they pass away, but they don't think that their child will be able to manage the these inheritance funds. So they'll include a trust in the will, so like a Henson trust, and they'll name a trustee that will be able to manage these funds for them. Now, if that were to happen, sometimes we do have the trustee of that trust contact our office, especially if the child beneficiary is on ODSP and the trustee, who doesn't have any dealings with ODSP and has no experience taking care of this child. They need help determining how to manage these funds so that the child's ODSP is not affected, and we certainly can help with that.
I'd like to speak to one question, Steve F. And he's asking, he says, this is a common question. He says, I'm located in Toronto. Can your office help clients in Toronto? We help clients all over the province. It's not just occasionally, but all the time. The practice is definitely a provincial and interprovincial and to some extent international practice. We have clients in England and on the Isle of Man and the States and other provinces. And so, when this virus came along, it didn't really affect our method of operation very much. And in fact, it made things easier because there was more motivation for Zoom meetings. Not that we needed that really, but the rules changed so that we could commission affidavits remotely, witness the signing of wills remotely. The law, practice of law, the state law, was finally brought into the 21st century. So this is actually a big improvement. And those first months were rather uncertain. We weren't sure what was going on, and that simply had to be resilient and respond, right, just like everyone else. But the building emptied out. It's not a big building. It's only 7 stories, but everybody else went someplace. So we stayed here in our little bubble and went home and stayed in our little bubble and served our clients just as always, because they're remote. So, if Ottawa has a population of 1 million and the province has a population of 13.7 million, you can see that only roughly 1 in 14 potential clients is in Ottawa, and it's the second largest city in the province. So that's that point. I'm going to briefly touch on lifetime benefits trust here. If you think that you might be a person who will have a sizable RRSP or RIF, then of course when you die, it'll become income in the year of death, and you'll have this sizable amount of money that is income. So you've been you've been working hard all these years, and you've been tucking money away. And yes, it's true, you've saved a certain amount of taxes, some maximum small amount every year, and then you die. And you pay in Ontario, potentially 53.5% tax on all of that money. So, there are lots of cases where that's not much of a plan, but it was the best plan you could have, that you thought. And you have a child with special needs. Now, you've got a couple of choices, and the bottom line, we can talk about, oh, well, I'll assign it to my child who has cognitive disabilities. Well, you sure as heck better have a guardian, right? And that amount of money then disqualifies the child, although they receive it, disqualifies them from ODSP. Or, well, I know I can put 170,000 of it, my child, who's not competent, by the way, can put 170,000 of it into his RDSP. Okay, but probably one of the better choices, especially for the more sizable sizable RIFs, is a lifetime benefit trust, which is designed to receive the money, and through an election, joint election by your executor, by your estate, and the child, it can be elected to have it fall into the lifetime benefit trust, which is separate but parallel to the Henson trust. And this is then rolled over on a tax-deferred basis to the lifetime benefit trust. The trustee of that trust then has only one choice. They must buy a qualifying trust annuity based upon the life expectancy of that child. So then what happens is the annuity pays to the trust. This is separate, again, separate from the Henson trust, but it pays the money to the trust, but it's, of course, it's all taxable income. But the income portion is all attributed to the child, the beneficiary. So I'll just give you a couple examples of how this works. One is this one with a $500,000 RIF, and this one, which is slightly smaller. So you can see here that if you have a $500,000 RIF and you die when you're 73, let's just say, and you know, you had your child when you were, because you're the mother, you die second. So you die at 73 or 83, you know, and the RIF is not exhausted because it's invested and growing, even at the same time that you must take money out and declare it as income. So you die, and you die in December, not January, so that the taxation is higher overall. And you have 500,000 that is income. You pay roughly, just for simplicity, 50% tax. Well, if in fact what you did was you died that same year and you had the money go through the gyrations that are involved here, if you know how the rules work, to the lifetime benefit trusts, you would have it paid out over the life of the child. And in this case, it says here that it's guaranteed for 20 years. And the reason we do this is not that that's all the child gets. The annuity runs for the child's lifespan. But if the child lives less than the following 20 years, well, then there is a remainder returned. And what this does is it would pay out to the trust this amount of money, but it would be declared as income in the hands of the child. So that child would use their disability and personal tax credits. And so the taxable income after the credits were applied is $3,000, resulting in $708 of taxes. Now that each year. Sorry, I skipped a slide there. So what this means is that over the 20 guaranteed years, we're just using this as a simple example. It's obviously, we want it to run for the lifetime of the child, but will run for the lifetime of the child. But if you look at that 20 years, you can see that the taxes of 708 times 20 is this number compared to that number. So it's a bit of a no-brainer.
This is my favorite magic that we do. I just love this.
And this one is slightly smaller. This perhaps is more realistic for more families. And we make these calculations using actuarial expectations, both for the parent and the child. And you know, this calculation is based upon the parent's age and the age at which they're actuarially supposed to pass on, and then the age of the child at that age, their age. And so if you have a $275,000 RIF, it's a more common number, you'd wind up paying at a maximum this number. But instead, if what happened was you purchased that annuity, the trust purchased that annuity with the 21-year guarantee, you can see that there wouldn't be any tax owing. So it's a difference between 0 and this number. And all this is the money that would have been paid in taxes. Because if you die in this way under this fact situation, Canada Revenue gets an amount equal to what your child gets if you don't do something about it, which I think is rather unfair. This is just some vocabulary about changes that have happened in the last few years and the words that relate to them. I'd like to point out this last point here, the changes to the principal residence exemption. It used to be that if you had either an inter vivus trust or a testamentary trust, and the beneficiary of that trust was your child, you could use it as his principal residence. But then in 2016, they changed the rules such that this doesn't work for inter vivus trusts set up specifically while you're alive to purchase housing for the child, shelter. And now it only applies for testamentary trusts where the child is approved for the disability tax credit. And of course, the problem with that is that there's a lot of kids with disabilities who don't qualify for the disability tax credit. You must be able to make the qualifying disability trust election for that trust in order to have the house approved for the principal residence capital gains exemption. So things have tightened up, but there are still lots of opportunities. Now, of course, if your child is approved for the disability tax credit, it could be less likely that they're going to be living in their own home that owned by the trust. Could be. But you can see that if one of the things that the testamentary trust is able to do is buy a suitable home for that child, perhaps shared with others, perhaps even with family, maybe. Well, if that is deemed to be a principal residence, when the child dies and the trust is wound up and the residue is distributed, the house is sold tax-free under today's rules. Does anyone want to speak to that? That's a bit complicated, but this is a suggestion that you consider life insurance to supplement the trust. If you were a female, age 50, non-smoker, your life expectancy simplistically is 35 more years. Now, if you get to be 85, then you'll find you still have another 6. That's just how it works. But simplistically, you have 35 years of expected lifespan. If you buy a universal life policy with a face value to pay out of 100,000, and of course you can do any multiple you want of that, 1,000, 100, 200, 300. But if you do 100,000, the monthly premium is $115, which is an annual premium of $1,384. So you can see that, you know, everything being equal, if you tried to save the premium, if you'd said, well, no, I'm not going to buy life insurance. I'm just going to not spend that $1,400 and I'm going to put it into a mutual fund. Well, one hopes you'll get growth on it, but simplistically, you can see there that you could only do it for 35 years because then you're dead. And in order to actually have 100,000, in this very simple example, you'd have to do it for 72 years to have 1,384, so to have $100,000. Now you can say, oh yes, well, yeah, there would be growth. Okay, well, what if that growth is 2% or 3%? And what if you pay tax on it and you're in a 33 or 44% tax bracket? You're being taxed on that 3 or 4% on the full amount, and you're paying 33 or 44% tax. Well, you're netting inflation. So you can see how simple this would be. And this insurance would be directly designated to the trust itself outside of the will. And what it would do is it would provide funds within a short period, let's say 30 days of your death, because someone, your executor or one of your children, would take the proof of death from the funeral home and fill out the claim form for the insurance, and we'd be paid to the trustee in a short order. And so if you're in a situation where you have been monthly subsidizing and supporting financially your child, and now your estate has to be probated, and the assets are tied up and to a large extent, then this would give you an immediate amount of money to settle onto the trust to provide for those immediate needs. We have about 6 minutes left, I think, for questions. Does anyone see anyone that they would specifically like to answer?
Ken, I would like to add to the answer that you gave about acting for clients or potential clients in Toronto. So to add to your answer, yes, we can. I have a client now that an elderly mother, and she wants to add her second adult child as a co-guardian. And so the disabled daughter, she's in Toronto. So we do work and do guardianship applications as well for clients who are not in Ottawa.
Clearly.
Yeah.
I see one here from Suzanne. If we just started our son's RDSP, RDSP last year, and he is 36 now, if we were to contribute the minimum $1,500, will he be able to make enough to sustain him after 65 when ODSP stops? Well, the way this works is if he's 36, at the very least, he has 13 more years he can contribute before he's 49, and there's no more grants and bonds. And depending upon whether his disability tax credit is backdated, but you just opened the RDSP, which, you know, could well be the case, right? then what you can do is certainly you can contribute going forward for 13 years of 20 maximum. So you're getting 13 of 20 grants and bonds. Plus, if the child was retroactively already years ago approved for the disability credit, but you just didn't set up the RDSP, which happens all the time. We have half a dozen, I personally have half a dozen consults each day and regularly find that, you know, this hasn't happened for various reasons. So if you set it up, you would receive retroactive bonds anyway, whether you contribute anything. And if you wanted to make retro contributions to buy back into the grants, there's a whole formula for that, which isn't that burdensome. And what we find is that a lot of the time, what we always try to do is we try to put money in your pocket first, and then try to find ways to assist you once you have money. So we do the disability and caregiver tax credit back filings. We have a contingent fee for that work. So if you get money, then we get paid. I think that's pretty reasonable. And the same thing with the benefit increases. We have a contingent fee. So if we succeed, then you have a bill. That's pretty fair. But if you do recoup $15,000, $16,000, let's say, for the disability credit, well, then you have the money available to make the retroactive contributions. There's certain limitations, of course, but retroactive contributions to pick up those lost 6 years.
Can I say one thing too?
Sure.
If this is new information to you, you can do another T2201 and just simply backdate it if you feel like your child would have qualified. Because sometimes the doctors don't fill out the form right, and they fill it out starting in 2020. And you can, you know, get that approval and get that going. And then you can get another T2201 and have it dated right now back to 2010. And pretty soon it's going to have to say 2011 because we're about to enter 2021.
Yeah. And we find lots of situations where for example, all of a sudden you change cities, or your doctor retires or some such thing. And then you're doing the T2201 and the new doctor, they say, oh, well, I haven't known you for 10 years. Well, yeah, that's true. But of course, if you can get the records, you know, how can you say that the child didn't have autism since he was 4? Well, it's one more of the little hurdles that we have to overcome. But that's just a way of talking around that question. I've got a couple more minutes. Does anybody have a question they'd like to answer?
I had a question about a Henson trust, I think. Yeah, about maximum amount that can be contributed, and can it be replenished? Should I be answering that, or? Yeah,
sure, speak to that. That's an intergenerational use of a Henson trust, yeah.
Yeah, so I think the question was from Bill. Bill, nice to hear from you. And we're glad to answer your question. I'm glad to answer your question, but I'm sure my colleagues support me in that. There is no maximum limit, to answer briefly. Regarding replenishments, replenishments from another person's passing is fine, but not during a lifetime of the person who is adding the funds. So the reason for this is because it would taint the testamentary nature of the trust. It used to be for testamentary trusts that a living contribution would make it lose its testamentary nature, and it would become an inter vivos trust. So this used to be a big deal because testamentary trusts would lose their preferential tax treatment. So that's one of the biggest things. Now it does not make much of a difference because both are taxed at the same rate. However, one thing to keep in mind is that there are other features of a testamentary trust that can be lost if it's changed into an inter vivos trust. So for example, making a qualified disability trust election and principal residence capital gains exemption, those would not be available in an inter vivos trust. So to answer your question, in summary, let's keep it to contributions in testamentary capacity.
Excellent. Well, I think that's a wrap. I've had a couple questions here about whether the people that receive the video and the PowerPoint slides, whether they'll get these questions and answers, and I believe the answer is no. They'll hear the questions and answers that we've taken, that have been dealt with during this webcast, obviously. And of course, beyond that, the simplest thing to do is to contact Karen, and we'll do our best to see whether there's, making some assessment of your family scenario and see what could be done for you first that would improve the situation, and what needs to be done over time. So with that, I think this is a great success myself. We had up to about 450 people, I believe, at the top of this taking part, which is more than half of the people registered. And I'd like to wish everyone a pleasant evening and good night.
Good night, everyone.
Good night. Thank
Good
you.
night.